Oh, hey guys. Wayfarer have responded to that letter that Lively filed, was it yesterday or the day before? Where she wanted to basically further brief her motion for the Section 47.1 remedies. I haven't read it yet, so it's going to be a reaction. I'm going to read it first, and then I'm going to do my bit of my thought process then after that. Then I was going to go through someone has done basically like a lip reading reel of Blake Lively at the Met Gala, and it's absolutely hilarious. I'm going to attempt to play it for you, so we've got a bit of humor to kind of wrap the video up with, but I will also post a link to it as well in the video description. Okay, so dear Judge Lyman, after agreeing to a settlement in which she dismissed her 3 remaining claims without the Wayfarer defendants paying a cent of the $300 million in damages she was demanding, I can see where this is going already. Plaintiff Blake Lively seeks leave to submit further briefing to address any impact of the court's intervening rulings since the Section 47.1 motion was filed, and to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and costs issues in light of these developments. Okay, so I'm going to read the footnotes. Plaintiff erroneously argues that all claims in the consolidated action have been resolved by the settlement, except one. Jennifer Abel's third-party complaint against Jones Works also remains unresolved by the settlement. Section 47.1b provides that a prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. And that part is key. It's only the costs that are associated with Wayfarer's lawsuit against. Cannot claim any costs that are associated with her own lawsuit against Wayfarer. She'll be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation, plus treble damages for any harm caused to them by the defamation action against them, in addition to punitive damages available under Section 3294 or any other relief otherwise permitted by law. Okay, so another footnote. Plaintiff mischaracterizes Wayfarer Studios. It ends with this movie stipulation with respect to the protected activity element of plaintiff's fourth cause of action for retaliation of California's FIHA. Those two parties simply agreed, and when they say those two, they're talking about Tag and not Tag, ends with this movie and Wayfarer, not Lively, because she did not agree. She wanted to file a letter. Those two parties simply agreed that for the purposes of trial only, and with respect to the FIHA retaliation claim, the jury will be instructed to presume that Miss Lively engaged in protected activity by complaining about posing a hostile work environment. Yeah, so she tried to file a letter to say, "Hey, judge, I've got some thoughts on the stipulation." She didn't sound happy, given that it was basically entirely for her benefit, but it would have meant that she couldn't have brought in all the evidence that, at trial, it would have given her so many headlines, which mainstream media, which we've already seen so much of, would have spun in her favor. It would have taken all that out, but then it would have completely eliminated one rather large hurdle that she had to overcome legally. So it was a win for her in many ways. If she had, this stipulation, it was for her benefit. And she still weren't happy about it. And she filed a letter, asked the judge if she could write a 5-page letter to address Wayfarer's stipulation. And the judge basically told her to sit down and shut up. No, you cannot file this. In fairness, the judge was going to hear her at the hearing, the Dalbert hearing that was supposed to be yesterday. But that has obviously now not happened. But I mean, Lively she was not happy about the stipulation for one reason or another, which we never got to find out what those reasons were, because the judge said you couldn't file a letter. However, she then completely mischaracterized the meaning of what Wayfarer were stipulating to in her letter, asking to further brief this motion. It's Lively's MO, to be honest. Okay. Plaintiff initially sought remedies under Section 47.1 in her March 20th, 2025 motion to dismiss Wayfarer's complaint, filed in response to Lively's complaint for, among other things, sexual harassment. On June 9th, 2025, the court granted plaintiff's motion dismissing the Wayfarer complaint, including Wayfarer's second cause of action for defamation against Lively. The court denied plaintiff's Section 47.1 request without prejudice, and plaintiff renewed the motion on September 8th, 2025. The renewed motion was fully briefed by September 29th, 2025. In her April 11th, 2026 pre-trial statement, Lively submitted that the 47.1 motion should be decided in advance of the May 2026 trial, and renewed her request that, if granted, the court should set a schedule to promptly quantify the monetary award to which Miss Lively is entitled, pursuant to Federal Rules of Civil Procedure 54D2C. Lively did not request or even suggest that additional briefing was necessary. At the April 28th, 2026 pre-trial conference, plaintiff again urged the court to decide the motion before trial, and, if the court found that the plaintiff qualified for relief under Section 47.1, instruct the jury that defendant's lawsuit constitutes retaliation, and then it would be up to the jury to determine whether that caused any damages. Plaintiff explained that the legal question of whether the lawsuit that the defendants filed was retaliatory is one that is before the court, and the court can decide and wouldn't have to take evidence on it. Plaintiff did not request additional briefing on the impact of the court's rulings subsequent to the dismissal of Wayfarer's defamation claim, but implicitly acknowledged that the court had sufficient information to rule on whether Lively was entitled to relief under Section 47.1. Plaintiff does not explain why, a week later, she believes supplemental briefing is necessary to address any impact of the court's intervening rulings since the dismissal of the Wayfarer complaint and plaintiff's 47.1 motion, or to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and costs issues in light of these developments. Plaintiff does not give any insight into the potential impact of post-dismissal rulings or developments, nor does plaintiff enlighten on how rulings subsequent to dismissal of Wayfarer's defamation claim could possibly impact or increase the cost to defend the dismissed claim. And of course, plaintiff fails to explain why the court which authored the subsequent rulings would need additional information to determine their impact on the remedies that may be available to a defence completed no later than June 9th, 2025. Simply put, plaintiff does not explain how her right to relief under Section 47.1 could be affected by subsequent rulings. The Wayfarer defendants respectfully request that the court deny plaintiff's request for further briefing, an evidentiary hearing, or other proceedings on whether plaintiff is entitled to recovery under Section 47.1. Very truly yours, Ellen Garofalo. Okay, so there was a lot there. Yes, okay, so if we go back to this part here, just going to go through it, pretty quickly, actually. So this is the language of the statute, right, which is Section 47.1b, provides that a prevailing defendant, which Lively technically would be, the complaint was dismissed. A prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled to their reasonable attorney's fees and costs. And then this is the key part, right? For successfully defending themselves in the litigation. Okay. So obviously the two cases were running alongside each other. Right? You had Lively, she filed first, you then had Wayfarer. You know, there's going to be a large amount of crossover. Lively cannot claim for anything that was generated by her own lawsuit. She can't claim for anything, any work that the attorneys did that was for her own lawsuit, only to defend Wayfarer's complaint against her. Okay, and the thing is, there is a lot of crossover. So really, there wasn't much, right? Because you know, the complaint came. I believe it was like either December the 31st or, you know, very early January, around that time. The start of January, and then it was dismissed by, you know, early June. So that's 5 months. That's not a lot of work, and all they really did was a motion to dismiss briefing. And then there's obviously the briefing for the motion for the fees and all that. So if she's successful, she can claim that too. So discovery is largely going to be very similar, you know, for the two cases. So, you know, I don't think there's going to be a lot of extra discovery that took place in Wayfarer's complaint against Lively that wouldn't have been already occurring in Lively's complaint against Wayfarer. The one thing that stands out, which I think would have been more specific, but I mean, again, it was something that Wayfarer did try to make relevant in their defense against Lively's complaint, but discovery from Marvel regarding Nice Pool, because it was Wayfarer's complaint that put Nice Pool at issue, as opposed to it being, you know, it was a defense in Lively's too. Don't get me wrong, but it was you know, more of a thing in no, it wasn't a defense actually, because Wayfarer didn't file a defense. They filed an answer. That's it. Yeah, so it was something that was put at issue in Wayfarer's complaint. And obviously, you know, there was discovery, a lot more of the defamation claims against the New York Times, for instance, Ryan Reynolds. So the discovery that went with all that, we actually saw a lot of that anyway in the Lively complaint, because it was part of the unsealed documents for a start. It's going to be really, really hard for you know, someone to kind of, they will be able to do it, but it will be incredibly hard to parse out what was billed for for Wayfarer, you know, to defend against Wayfarer's complaint. The second part of this then is plus treble damages for any harm caused to them by the defamation action against them. So again, we know there was a spike in online negative sentiment against Lively. Her own expert, Dina Maislin, I think it is, showed that in the various graphs and things and talked about it in her report. Now, she actually had a bigger negative spike when she filed her lawsuit, even more so than she did in August when she said that, you know, Wayfarer retaliated against her. Now, the thing is did that spike occur because people were still, you know, were pissed off with Lively and then she filed this lawsuit? Or did it occur because Wayfarer then filed their complaint? And that's going to have to be kind of the deciding factor. But also, I was looking at what did Wayfarer file, because Lyman said in his order on the motion for summary judgment, Wayfarer are entitled to defend themselves. And they're allowed to use proxies to do that too. Now, one thing that Wayfarer's complaint did is Lively, just as an example, right, of some of her complaints. I'll use two, right, just to save some time. Two complaints. Lively's complaint said, I did the birth scene completely nude, or just wearing a thin piece of nude color fabric, right? And I was basically left with my legs in stirrups. You know, I had no choice. I was forced to do it, etc., etc. And there was no nudity rider. And then one of the other claims she made was, well, Baldoni and Heath, they just wandered into my trailer whenever they wanted. Every time I was breastfeeding or topless, they just wandered in, you know, uninvited. Now, what the job of Wayfarer's complaint specifically was, and I think it was always for this purpose, more so than to file, you know, a serious lawsuit, was to counter that. But they didn't come in and, you know, aggressively and go, Lively's a liar. They said, actually, that scene, that birth scene, you were wearing this, 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 and this. And by the way, did you forget that we were filming? You know, we've got the footage. Probably forgot about that because she was trying to destroy the dailies per Sony's text. And then the allegation that Baldoni just wandered into her, you know, trailer every time she was breastfeeding or topless for some reason. And then it's like, well, no, actually, by the way, here's a text message. Don't just take my word for it. And that's not defamatory. It's defense. It's not defamatory because it's true. So therefore, you know, saying, look, I'm being accused of all of this, but actually here's the evidence that it's not, that what she's saying is not true, or, you know, to put it better, I guess, is here's the evidence that I did not do what I'm being accused of. And then, like, really, should a guy be punished just because his complaint was dismissed when what he was really doing was telling the truth and proving his innocence? I'm not sure. See, I'm not convinced Lyman is going to rule on this. And even if he does, I think he will deny it. And if he does, Lively also does not have a right of appeal. Just to clarify, Wayfarer waived their right of appeal against an order if Judge Lyman grants this. However, you know, I'm pretty sure Lively does not get a right of appeal because once there's a judgment, if Judge Lyman says he doesn't grant it, he denies it, then I'm pretty sure that Lively also effectively, because the case is now settled, waives her right of appeal. I feel like that's where it is. It's hard because this is obviously, you know, case of first impression. So it's hard to know what will happen here. But I can only give you what I think may happen. But Wayfarer are kind of saying, look, and this is really important. Since the case was dismissed back in June, right? Wayfarer's complaint was dismissed in June last year. Lively has had to do nothing with that case. That's it. It stopped, right? And everything that continued since happened in her lawsuit. Apart from her filing her motion to request this 47.1 fees, etc. Nothing else happened. And what Ellen's saying here is, well, hold on a minute. What do we need 5 pages to tell us more? Nothing else happened. It was already fully briefed in September. Because the judge initially said no, he wasn't going to consider it, but he did that without prejudice and said to Lively, look, you can renew the motion and I'll consider it. That was all fully briefed before October. And then before, in the run-up to the trial, at the pre-trial conference, Lively was saying, look, you don't need any further information. Can you please make a ruling before trial? You know, because the court has got all the information it needs. And as nothing else that happened anyway, you know, from the time that, you know, the Section 47.1 motion was briefed, then there's nothing else that she's had to pay out to defend herself again. And then nothing else has happened that would have caused any further damage to her reputation. And Wayfarer is saying, okay, so between, you've done nothing more from this point in time anyway. And the fact that, only a week before the settlement, you told the court in this conference, in this hearing, that, the court had all the information it needed. So why do you need now 5 pages to write more? What else is missing, is what Wayfarer technically saying. And then further to that, Lively's going to try and throw in the stipulation. She's going to try and probably, throw in, various bits and pieces. And just, I think it'll be a PR spin, Wayfarer and others. But also Wayfarer make a really good point of, you say you want to, you need the supplemental briefing to address the impact of the court's, intervening rulings since then. But the court was the one that wrote those rulings. Like, do you need to tell the court how to suck eggs? Like, that's the effect of, like, she's law-splaining to the judge his own rulings. That's the best way I can kind of surmise what Wayfarer are effectively saying here. Like, well, you don't need to do this, do you? Because the court knows what it meant and it knows the impact of its own rulings, but also you haven't explained why this is necessary. And that's where we are. So Wayfarer are like, no. She's already said this was already briefed. The court had all the information. Just judge, make a decision. And we already think that the judge is not inclined to grant it. I don't think he's going to grant it. More than anything, I don't think that Lyman's got jurisdiction over it anymore. Now the case is settled, and effectively that's it. It's done. I will probably spend time, and I'll do a standalone video, I think, on that a little bit more, because it's an area which really interests me in this. So I'm kind of, my interest is piqued because this is now standing still on its own, and it's a case of first impression. So it's very much just interpretation, and I can kind of let my thoughts go a little bit wild. So I'm going to do a standalone video. Probably tomorrow now, because it's nearly 10 o'clock at night here. And I'll go through that, my thoughts anyway, a little bit more in detail. Now for some fun. Bear with. Okay, I'm going to give this a go. It has got subtitles anyway, if you can't hear it, but the voice is quite funny. But I will also leave a link in the video description. But this is the lip sync, the lip sync of Blake Lively at the Met Gala.
Okay, it's not that difficult. You've just lost your job, babe. Yeah. Are you just gonna stand there? I'll do it myself. For goodness sake. Oh. Oh. Now go away. Move it, you pathetic dork. Oh, sorry. They work so hard. I have to be nice. Hello, is anyone gonna get this?
Oh,
yeah. I'll get it.
We love you, Blake.
I hate you. Okay, just, you're causing me all this trauma. Do you believe that one day you'll have to answer to Jesus? I only answer to Ryan.
So yeah, that's pretty much it for now from me. Let me know what you think about that letter, though. Hopefully we'll get a ruling from Judge Lyman pretty soon. I kind of do want Lively to be allowed to file it, because I just want to know what she's going to say about it. All right, guys. Have a good evening.